Hello Year 11s, welcome to this video on the presumption of innocence. There are three things that you need to do while you're watching this video. The first is to take the very best Cornell notes that you can. The second is to use the pause and rewind functions. Use the pause function if you need to stop this video so that you can take notes. Use the rewind function if you've missed any information or if you want to go back over any information. The third thing that you need to do is have your vocabulary sheets open in front of you. You must write into your vocabulary sheets the definitions of important terms or of any other words that you may be unfamiliar with. Once you've finished watching this video, please read the pages from the textbook referred to on this slide. If you find any additional information from that reading that you think is useful, please supplement your Cornell notes with that information. Let's get started then. On this slide, I've set out your learning intention for this video. Make sure that you write this in your Cornell notes. This learning intention is that you should be able to describe and explain three very important concepts in criminal law. These concepts are the presumption of innocence, the burden of proof in a criminal case, and the standard of proof for a criminal case. The first concept then is the presumption of innocence. The presumption of innocence is that a person accused of a crime is presumed innocent unless or until proven guilty. Look down the left-hand side of your vocabulary sheets, find the term presumption of innocence and write this definition in there. The presumption of innocence is a fundamental principle that underlies our criminal law. What it means is that an accused is never required to prove that they are innocent. Instead, it is for the prosecution to prove that the accused is guilty. The presumption of innocence is important so that the accused can have a fair trial.
As a result of the presumption of innocence, both the judge and the jury must start from the position that the accused is innocent, and it is for the prosecution to prove instead that the accused is guilty.
The presumption of innocence is included in the Victorian Charter of Human Rights and Responsibilities. Section 25 of the Charter states that a person charged with a criminal offence has the right to be presumed innocent until proved guilty according to law.
However, the Victorian Charter of Human Rights and Responsibilities did not introduce the presumption of innocence into our law. On the contrary, the presumption of innocence has actually been a part of our law for hundreds of years, and the Victorian Charter of Human Rights and Responsibilities simply reflects the existing law.
The reason that we have the presumption of innocence is that the consequences for a person who is wrongly convicted of a crime can be extremely serious. Let's take the case of murder. If a person was to be wrongly convicted of murder, that is, they are found guilty of a murder that they did not commit, then you've virtually destroyed that person's life. They will typically be sentenced to a very long term of imprisonment, which means that they are being deprived of their liberty for a number of years. They'll be isolated from their family and friends. Their reputation will be destroyed. They won't be able to earn money because they're stuck in prison. They'll be associating with criminals. They'll be living in very, very unpleasant conditions. They'll have a criminal conviction. And when they're released from prison, they'll find it very hard to get a job precisely because they've had a criminal conviction. It is because the consequences of a person being wrongly convicted of a crime are so serious that we take the view, under Australian and Victorian law, that a person should be presumed to be innocent until or unless they're proven guilty. Now that means that we also accept a risk that guilty people will go free.
Because in some cases, the prosecution will not have enough evidence to be able to prove that the person is guilty.
Nonetheless, when we weigh up the consequences to an innocent person of being wrongly convicted of a crime against the risk that guilty people will go free, we take the view that it's better to err on the side of protecting the innocent from being wrongly convicted. This approach has been summarised by Sir William Blackstone, a famous lawyer, who a long time ago said, It is better that 10 guilty persons go free than that one innocent person is convicted. Another important concept in the Victorian criminal justice system is the burden of proof, sometimes referred to as the onus of proof. The burden of proof is the responsibility of a party to prove a case. In your vocabulary sheet, please find the term burden of proof and include this definition in there. In a criminal case, it is the prosecution that generally bears the burden of proof. That is, it is the prosecution that must prove that the accused has committed the crime. What this means is that the prosecution has to prove the existence of each of the elements necessary to establish the crime. Typically, a crime will consist of an actus reus, the physical act that makes up the crime, and a mens rea, that is, the state of mind that the accused must have to be guilty of a crime. In the case of murder, the actus reus is the killing of the victim, and the mens rea is the state of mind that the accused must have when they kill the victim to be guilty of murder. This includes the accused having the intention to kill or cause really serious injury to the victim. So thus, in a murder case, it is for the prosecution to prove both that the accused actually killed the victim and that when the accused killed the victim, the accused intended to kill or really seriously injure the victim. The fact that the prosecution has the burden of proof upholds the presumption of innocence.
This is because if a person is presumed to be innocent, then the person does not have to prove that they are actually innocent. Instead, it is presumed that they are innocent. The consequence of this is that it is for the prosecution to prove that the accused is in fact guilty, and that is precisely what the burden of proof requires.
Because the prosecution has the burden of proof in a criminal case, it is for the prosecution to prove that the accused is guilty of the offence with which they have been charged. The last concept that we need to look at is that of the standard of proof. The standard of proof is the strength of evidence needed to prove a case. In your vocabulary sheet, please find the term standard of proof and write this definition next to it. In a criminal case, the prosecution must prove beyond reasonable doubt that the accused has committed the crime. That is, the standard of proof in a criminal case is beyond reasonable doubt. Beyond reasonable doubt means that the only reasonable explanation for what happened is that the accused committed the crime. If there's a reasonable doubt that the accused committed the crime, then the accused must be acquitted. The standard of beyond reasonable doubt is a very high standard indeed, because, as we've said, if there's any other reasonable explanation for what happened, other than that it was the accused that committed the crime, then the accused must be acquitted of that crime. To give you an example, let's assume that there were two identical twins who lived next door to an old man. The twins held a party late into the night and had lots of loud music and lots of friends. This annoyed the old man, who called the police, and the police came and told the twins to turn their music down. The twins were very irritated and upset by this, so one of the twins went next door and bashed the old man to death. Now, the police don't know which of the twins actually killed the old man. So when the first twin is brought to trial, that twin must be acquitted of murder, because it cannot be proved beyond reasonable doubt that that twin actually committed the murder. An alternative reasonable explanation for what happened is that the other twin committed the murder. Similarly, if the second twin was brought for trial, then the prosecution would need to prove beyond reasonable doubt that that twin committed the murder. However, once again, the alternative reasonable explanation is that the other twin committed the murder, and so the twin who has now been charged with the murder would have to be acquitted. The fact that the accused's guilt must be proved beyond reasonable doubt also upholds the presumption of innocence.
This is because if a person is presumed to be innocent, and if there is a reasonable explanation for what happened which is consistent with the accused's innocence, then the accused is entitled to the benefit of that alternative explanation and should not be found guilty. Put another way, as a result of the presumption of innocence, an accused should only be found guilty of a crime if the only reasonable explanation for what happened is that the accused did actually commit the crime. And that is precisely what the standard of proof requires. For an accused to be found guilty of a crime, the prosecution must prove beyond reasonable doubt that the accused committed that crime, which means that the only reasonable explanation for what happened is that the accused committed the crime.
As I've said, the presumption of innocence is a fundamental principle which underlies our criminal justice system. In addition to the burden of proof and the standard of proof, there are other features of our criminal justice system that uphold the presumption of innocence. The first of these is bail. Bail is the release of a person who's been charged with an offence on the condition that they appear at court for their trial. If a person is not granted bail, then they are held on remand, that is, they're held in jail until their trial.
Now, the rule is that a person who has been accused of an offence, that is, they've been charged with an offence, will be granted bail unless there are good reasons to hold them in custody, that is, on remand. Good reasons include that the person has been charged with a very serious offence, such as murder, or that the person is likely to skip bail, that is, they're not likely to turn up at their trial, or that the person is likely to interfere with witnesses. But apart from these situations, the rule is that an accused will be granted bail. This is because such a person has only been charged with an offence. They haven't had their trial, so they haven't been found guilty of that offence. This upholds the presumption of innocence because if a person is presumed to be innocent, then that person should not be held on remand in jail until their trial. You don't put an innocent person in jail.
The second feature of our criminal justice system that upholds the presumption of innocence is that an accused has the right to silence. This means that an accused can refuse to answer questions asked by the police and can refuse to give evidence at their trial in court without being presumed to be guilty.
So, for example, if an accused exercises their right to silence by refusing to give evidence at their trial, then neither the judge nor the jury can conclude from the refusal of the accused to give evidence that the accused is guilty. This upholds the presumption of innocence because if a person is presumed to be innocent, then there is no reason why they should have to answer police questions or give evidence at their trial.
The third feature of our criminal justice system that upholds the presumption of innocence is that before the police can arrest a person for a crime, they must reasonably believe that that person has committed the crime.
This upholds the presumption of innocence because if a person is presumed to be innocent, then the police should not be able to arrest that person for committing a crime where the police have no real reason to believe that the person has in fact committed that crime.
The fourth feature of our criminal justice system that upholds the presumption of innocence is the test that a magistrate must apply in deciding whether an accused who has been charged with an indictable offence should be sent to trial in the county court or the Supreme Court for that offence. An indictable offence is a more serious criminal offence which is heard by the county court or the Supreme Court, such as murder, burglary, violent assault or kidnapping. Where an accused has been charged with an indictable offence, then they must first face a committal hearing in the magistrate's court. Now, this is not the trial of the accused for that offence. The accused's trial will instead be held before a judge and jury in the county court or the Supreme Court. But the purpose of a committal hearing is for the magistrate to determine whether the prosecution's evidence is of sufficient weight that a jury could, not would, but could convict the accused at their trial in the county court or the Supreme Court. The reason for having a committal hearing is so that very weak cases, that is, cases where a jury is unlikely to convict the accused, are not sent to trial.
Committal hearings uphold the presumption of innocence because if a person is presumed to be innocent, then that person should not be subject to the cost, time and stress of a trial where the prosecution's evidence is so weak that a jury is unlikely to convict them.
The final feature of our criminal justice system that upholds the presumption of innocence is that the fact that an accused in a criminal trial has prior convictions must not be disclosed to the magistrate or to the judge and jury during their trial.
This upholds the presumption of innocence because if a person is presumed to be innocent, then the fact that the person has committed previous offences doesn't mean that they have committed the offence for which they are now being tried. Suppose that Max is on trial for stealing $50,000 from Anita. Just because Max has previously been convicted for stealing $30,000 from Michael does not prove that Max actually stole the $50,000 from Anita. Instead, it's up to the prosecution to provide sufficient evidence to establish beyond reasonable doubt that the accused, in this case Max, has actually committed the crime with which they have been charged. And the fact that an accused has prior criminal convictions is generally irrelevant to this question. It's only if the accused is found guilty of the crime that evidence of the accused's previous criminal convictions becomes relevant. This is because evidence of an accused's previous criminal convictions is relevant in determining the sentence that the judge or the magistrate is going to impose upon an accused who is found guilty of a crime. An accused who has previous criminal convictions will typically be given a more severe sentence than an accused who has no previous criminal convictions. The important point is that the evidence of an accused's previous criminal convictions is not disclosed to the court until after the accused has been found guilty, because until the accused has been found guilty, they are presumed to be innocent. And it would be inconsistent with the presumption of innocence for an accused's previous criminal convictions to be taken into account in deciding whether an accused is guilty of a later offence.
Well, that now brings us to the end of this video. You should now be able to describe and explain the presumption of innocence, the burden of proof in a criminal case, and the standard of proof for a criminal case. In relation to the presumption of innocence, you should also be able to describe and explain those features of our criminal justice system that uphold that presumption. There's only one more thing you need to do. Please make sure that you read the pages of the textbook referred to on the first slide, and if you find any additional information from that reading that you think is useful, supplement your Cornell notes with that information. Thanks very much for your attention.